Attorney Michael Avenatti is between court appearances at this hour. Earlier today, he pleaded not guilty to stealing about $300,000 from former client Stormy Daniels. Prosecutors say he forged her signature to divert a book advance to his own accounts. Avenatti due back in court less than an hour from now to answer the charges he tried to extort millions from Nike, with claims the company paid high school athletes to steer them to Nike-affiliated colleges. Let's bring in Philip Holloway, a criminal defense attorney and host of the Sworn podcast. It's good to have you here. I want to read to you Avenatti's tweet from last night. He said, "Have trust in the system that I have devoted nearly 20 years of my professional life to. I am confident that I will be fully exonerated by a jury once all relevant evidence and documents are presented. And I look forward to a full inquiry into the motivations behind the charges." Okay, that's true, right? So innocent until proven guilty. But how do you think he looks right now?
Well, Dana, that's quite a bold statement for someone to make, because even the forgery aspect of this case having to do with Stormy Daniels, that is usually a very simple thing for prosecutors to prove. All they really need to have is a copy of the document or the original of the document with the signature that they say is forged, and then they need to have the person whose signature it's supposed to be, in this case Stormy Daniels, to cooperate, to sign an affidavit to say, look, that's not my signature, and then to potentially come into court to say, that's not my signature and I didn't authorize it. It is okay for lawyers sometimes to sign their client's signature, but they have to have permission to do so.
And it appears that that was not the case here. But tell me then about the case that Nike brought to the attention of the federal government, saying, look, this guy's trying to extort us. What do you think of that? How is his position there?
You know, a law license is not a weapon, Dana. It's merely an authorization to represent someone in a real case or real legal controversy. In this case, it's not really clear who, if anyone, he was actually representing when he allegedly went to Nike and said, hey, I've got this damaging information, and unless you pay up, I'm going to expose you to the world on the eve of your quarterly earnings report. So if it's used in that way, the way prosecutors have alleged, that is simple extortion outright. You cannot use your law license as a weapon. And even if he did have an actual client, and he says he might, it's hard to understand how this information, even if it's true, could have actually harmed any particular person that would give rise to a legal controversy such that he might be able to sue over it in court.
Well, we'll see what happens to him. No doubt he's got so many. We just scrolled through all the charges against him. I mean, he's got a lot going on. But I do want to ask you about this case in Oklahoma where Johnson & Johnson is being taken to task by the state of Oklahoma about opioids. Take a listen to the Attorney General of Oklahoma on this.
Public nuisance, that theory, common law and statutory, is designed to protect the people in a community and in a state. And when thousands of people die from drug overdoses attributable to prescription drugs, when you have hundreds of thousands of people who are addicted, public nuisance law is the best and most efficient way for you to protect the people of your state.
Other opioid makers have basically settled other cases against them, but Johnson & Johnson decided to fight this one. 775 people died of opioid overdoses in Oklahoma in 2017. So how will they make their case in front of the jury?
Well, there's no jury. This is actually a judge trial, and that makes sense. You know, if you put a case in front of a judge and you take a jury out of it, you take the emotional aspect out. And there's not a person that I know of, myself included, who doesn't know someone who's been personally affected by the opioid crisis, and to be sure, it is a crisis. But this is not like you're going after a doctor and saying you're overprescribing, or to a pharmacist and saying you're violating the rules so that we can perhaps prosecute you criminally. They're going much further upstream after Johnson & Johnson. And these are the folks who procure the chemicals that go into the actual pills. And to say that this somehow violates the public nuisance law in that state, that is going to be a much, much harder thing to sell to a judge. It's purely a legal issue. It's causation. You've got so many other factors at play. You got doctors who are involved in the prescription process. You've got people who abuse this stuff. And you've got the federal government through the FDA who has given its stamp of approval and said these drugs, they're safe and there's a legitimate medical use for it. So it's going to be a tough row to hoe, I think, for the plaintiffs in this particular case.
And no doubt every company and state attorney general is looking at the outcome of what this is going to end up being.
Oh, there's no question about it. There's lots of these lawsuits almost in every state in the country, and lots of them are consolidated in one court. So if you see this manufacturer winning this case on legal grounds, it's going to affect whether or not other defendants in these other lawsuits nationwide are more likely to settle or perhaps take their own case to trial if the defendants in this case win.
All right. Philip Holloway, thanks for being here, and check out his podcast, Sworn. I love it.